like I said, you won the election. You had a vision for what you wanted it to be. And you aren't necessarily, I mean, if you were the assistant of whatever, and now you're becoming the head person of an office, things might be fine. You might be very happy with the staff, but you might have run against somebody in a contentious election, or you may have a different idea than your predecessor about how things ought to be run. And so since you have to get things done with your own staff, you have to make a decision: who stays, who goes, what flexibility do I have to name the team that I want? And one piece of advice that is certain, and it applies to everyone: if you're not sure you can dismiss an employee, talk to your attorney or HR director before you take any action. If you take the action, you're going to be talking to us about how you're going to be defended. So the real question is, can you fire anyone you want when setting up your administration? What do you think? That's exactly right. Libby?
And I'll start out by telling you that John and I apologize. We understand that there was a printing issue, and so you do not have these handouts in front of you right now. I know some people are very visual and they like to take notes on that, so I regret that you're not able to do that at this time, but we do hope to get the slides to you so you have the information available. So I'm going to talk to you about some of the general rules that apply. You guys, everybody audibly got the answer right. You cannot just come in and fire everyone. You can't clean house and get rid of everybody just because you've been elected. So what you guys need to know is who can you get rid of and who do you have to keep and what do you have to do to determine who falls into which category. So today we're going to talk about the rules that apply. The general rule is what you just heard. You can't get rid of somebody just because you've been elected to office and they're not of your political affiliation, or they didn't support you, or they weren't somebody that you hired. There are two exceptions that we'll talk about. Those exceptions are for what we call policy-making positions and confidential positions. The reason that the answer to that first question is no is because of the First Amendment. We hear about the First Amendment oftentimes related to free speech or free press. The First Amendment also protects a person's right, freedom of association. So somebody has a right to associate with any political party or any group or any particular individual that they want to. And as a government employer, you cannot retaliate against them based upon their decision to affiliate with either that person, that party, or that group. This is also something that I would point out is particular to governmental entities. So if some of you have come from a HR background, or if you've been involved as a supervisor in the private industry for a while, keep in mind that the First Amendment is particular to government employers, and this is probably something that you've not had to address before. So as I mentioned, the First Amendment covers more than what you think. Somebody's political activity, their political affiliation, and their speech, whether that is political or not, is covered by the First Amendment. So if you terminate an employee for some political activity they engaged in, for whether they supported you or another person or failed to support you, or for whether they spoke up during the election or after the election, or they said something in particular about who's qualified to do this job, you keep in mind you're going to be violating their First Amendment rights if that's the basis for your termination. And again, this is the general rule. Assume this applies to most employees. The clearest example that we see is when somebody comes in and they clean house. That is the easiest time for employees to claim that they have been fired for political association or political speech. So if you come in and you get rid of everybody, there's sort of a presumption that your decision was based upon political affiliation or political activity. Some people say, hey, I'm coming in and I'm cleaning the house for a whole nother reason. I think this office has been run inefficiently for years, and I've got this great plan to be more efficient, and I'm going to reorganize the entire office, and in doing that, it's going to be less expensive to the county. And so in order to do this, I'm just going to clean house and get rid of everybody. Those are all goals that you can have. You can come in and say, I'm going to be more efficient in my office, and here's how I'm going to do it. But keep in mind that if you clean house, there's going to be an idea that your theory or your goal of greater efficiency is pretext, which is a fancy way of saying a lie. So if you come in, clean house, an employee is going to often claim that they've been discharged for their political association, political activity, or political speech, even if you've got some other reason that's behind that. So now we've warned you about what can happen and what can't happen. If an employee decides, if you terminate an employee and they decide that they've been terminated in violation of their First Amendment rights and they want to pursue this, they actually have the burden of proof. In this country, the person who brings the lawsuit has the burden. So what does that employee have to do? If you get rid of an employee, they're going to have to prove that their conduct was constitutionally protected, meaning that they did engage in some political activity or political speech, or that they were associated with an individual for which they had a right to be associated with, and that their conduct was a substantial or motivating factor in your decision to end their employment. I would mention on that slide, by the way, we were talking about terminations in particular. There's technically a third element, but that's an adverse employment decision. They have to prove that they were subjected to an adverse employment decision. If somebody's terminated, that is always an adverse employment decision. But keep in mind that deciding to alter someone's job for all of these same reasons, you say, you know what, fine, I'm not going to fire them. I'm just going to take away all their responsibility, and I'm going to, by the way, move their desk into the corner. You know, that broom closet looks like a great place for Sally to work for the next year. And basically, I'm just going to make her life miserable until she leaves. Oops. I may have lost my slide there. Keep in mind that that is also an adverse employment decision. So while you've got these two factors to prove, termination is technically the third factor. That's pretty easy to prove. But if in fact you're changing somebody's job duties and you're taking an adverse, making an adverse impact on their job, they can use that as well, even if you haven't terminated them. And if they can prove that adverse impact on their job, then they can pursue their claim. So again, talking about the burden of proof that the employee has, oftentimes when we're talking about the First Amendment, there are several things that they can come in and say. They can say, I attended rallies, I gave money to the opposing candidate, I went out and handed out brochures, I knocked on doors, I did canvasses for the other candidate. In smaller counties, people always come and tell me, everybody knows what everybody does. And so there's no question that the person who got elected knew that I was out there campaigning for the opposition. In larger counties, that's a bit more difficult. But that's an important element because an employee needs to prove that if you have made a decision to get rid of them and they believe your decision was politically motivated, then you obviously have to know that they had engaged in some sort of activity. The mere fact that you are an R or a D and that the employee is of the opposite letter is not enough. It's not enough to say that person was registered as a D and you got rid of me, and therefore that shows a political affiliation there. We can talk about employees that are Rs and Ds. There are also employees that are apolitical. They don't come out and necessarily support any particular candidate. Those employees can bring a claim. They can say that their firing was politically motivated, even though they didn't support you and they didn't support their opponent. Those claims are allowed, but those employees, again, have the burden of proof. They have to present some sort of evidence. Those are pretty hard claims for an employee or a former employee to prove, but just keep in mind that is a possibility. Just because someone is apolitical does not protect you necessarily from a First Amendment claim. So our ultimate goal here is to avoid lawsuits. How do you do that? One of the things that I tell people about is when a case gets to me, you've already been sued most of the time. So what am I going to be wanting? I'm going to want your documents. I'm going to want everything you got that's going to prove why you made your decision. When you're new to office, you don't come in with a stack of disciplinary records that you've done write-ups for this individual, you've given them warnings. So when you're brand new to office and you get rid of somebody, that documentation can be pretty slim. That means it's important from the defense standpoint for you to have something documented to show why you made your decision. Let's say that someone is, you have worked in, I'm going to use the clerk's office as an example. You've worked in the clerk's office for years, and Jane's worked next to you, and now you're the elected clerk, and you happen to know that Jane is late every single day. She takes a 2-hour lunch break. She really doesn't do any of her work. She makes excuses. She pushes everything off on everybody else. You've got years worth of emails where she's sent things to you telling you to do certain things that was supposed to be within her job description. You've got evidence of all these tasks that she didn't do on time, reports that she didn't get completed, money that she couldn't explain where it went. Have that documentation. If that's your basis, if you're going to say to me, Libby, I got rid of her and it has nothing to do with what letter she's associated with. I got rid of her because she's a bad employee. And I know she's a bad employee because I've worked next to her. Have your documentation ready. This is getting your ducks in a line. You may walk in on that first day and know that you want to get rid of somebody, but make sure you've got your ducks in a line before you do that. If an employee can demonstrate that their political affiliation was a factor in your decision to terminate them or change their job responsibilities, then the burden shifts to the employer. So when we start out by saying, here's what the employee has to prove, there's what we call the prima facie case. It's a threshold, and if they meet this certain threshold, then in fact you as the employer needs to come in with your evidence and your documents to show the real reason for your decision to terminate or to change their job. What I tell people is if you can't explain to me why you got rid of somebody, it's going to be a tough case to prove to a court or to a judge that it wasn't a politically motivated decision. So again, the more information you have, the more documents you have, and the more thought that you've put into it before you make that decision, the easier it is to defend that case. All right, that's our general rule, and assume that all employees fall in that category. Here are our exceptions. The first exception is for policy-making positions. And it's high-ranking public officials who provide meaningful input into developing policies and goals can be dismissed for even political reasons. That's sort of a long, maybe awkward definition for policy-making positions, but this is one of the reasons that, as John stated in the beginning, if you're going to get rid of somebody, talk to your HR person, talk to your attorney first, because that definition is not that clear. It's not that easy to say you always know who falls into this category. So just because you think somebody is a policy-making position doesn't mean that the courts are going to agree with that. Make sure you run that by somebody first. The reason that these policy-making decisions, policy-making positions can be terminated, or those individuals can be terminated based upon a political affiliation, is because you've been elected for a reason. And generally, you need to have people that demonstrate some sort of loyalty to fulfill those goals and promises that you've set forth for your administration. So to facilitate you being able to come in and implement your new goals, to make your office more efficient, to minimize the cost that's involved, to make it a happier place for the general public to come visit, you need to be able to have people who can implement those policies for you. And so you need to have those people who have loyalty to you and that you've actually chosen to work for you, because if they're not going to implement your policies, your hands are tied, and you're not going to be able to accomplish the reason that the people elected you to office. As this highlights again, it is difficult to determine whether or not an employee is a policymaker. There is no specific checklist that I can provide for you, but again, make sure that you run that by someone. The general test that we sort of talk about is, does the position authorize, directly or indirectly, meaningful input into decision-making on issues where there's room for principled disagreement on goals and their implementation? Once again, this is why lawyers have jobs. I get that this is difficult, but this is the process you have to go through. You have to think about these things. You have to think about how directly somebody is really involved in making policy. You come in and you say to your chief deputy, I want us to be more efficient. Now, bam, you tell me what we have to do to be more efficient. Those are the sorts of people who create the policy. They sit down and they say, well, this is what we're going to do. We're going to streamline this process right over here. We're going to go online with this process, and we're going to make this information available this way. That person is making the policy that's going to be implemented to reach your goal. So these are the questions that we look at. How directly were they involved in that? How much principled disagreement could there be? Could people come in and be disputing whether or not, this online process makes sense, or if it's the best way to be more efficient, or if it's just cutting people out of the loop? Those are the sorts of thought processes that need to go into these things. Some examples when we're talking about policymaking positions: an official statutory deputy. There is a statute in Indiana, and we'll see this again in the slides, but auditors, treasurers, recorders, and sheriffs are all covered by one statute, and that statute says that each of those elected officials have a right to name their chief deputy and as many deputies as are allotted for in their budget. So if your council has already determined that your office has a line item for 4 deputies, you're entitled to determine who your 4 deputies are. You don't get to come in and name 6 deputies because that's not within your budget. But if your office is allotted 2 deputies, you get to come in and name those 2 deputies. There are other statutes that apply to other offices. Just because your office wasn't listed in that particular list, don't think you don't get to name your chief deputy. But those are particularly identified. Coroners, assessors, surveyors, I know are all identified in separate statutes, and that's because each one of them has something that's just a little unique in those. Directors of departments who answer directly to the elected official, and officials appointed by the previous administration. Be very careful with this last one. So we're talking about appointed individuals. That does not say somebody who was hired by the prior administration. People who are appointed to a position are often appointed to a policy-making position. The specific nature of the position is what we need to be looking at. If you have a job description, that is great. And your job description is what we're really going to rely upon. Your employee may have their own description of what they do. That's not the primary basis for determining whether or not that position is a policy-making position. So make sure you've got your job description and take that into consideration before you make these decisions. Our second exception to the general rule is what we call the confidential position exception. An employee who holds a confidential and trusted position can be dismissed for political reasons, just like a person who holds a policy-making position. The easiest way, and this is very bare bones basic, so do not rely upon this for all of your decisions, but the easiest way to talk about the difference between these two, just so you know where we're going here and why there are 2 exceptions, consider your chief deputy to be your policy-making exception, and consider your secretary to be your confidential position. And we'll talk a little bit more in detail how this confidential position is different. So generally, your secretary is somebody that you trust with your most sensitive information. They are the person that people come into the office, and they're the first face. They're the gatekeeper, we like to say. They provide information that goes to you and information that comes out of your office. They make sure it goes to where it's supposed to be. They make sure that if you're supposed to be filing a report and you give them a report, that report actually gets filed and it doesn't just go in the trash can. This is a quote from the court that sort of helps explain why a secretary falls into this position of confidential. A mayor's secretary can undertake these functions or those functions in relation to the flow of information, whether in writing, speech, or personal visits, to or from the mayor's office that the mayor wants the secretary to perform. So in other words, If you want to make sure a letter goes out, you need to trust that your secretary's got this information and they're really going to do what you're telling them to do. You need to trust that when you're thinking things over and you're sending out memos to your chief deputy saying, hey, here's what I really want to talk about. Here's an issue that I think we need to address. You need to make sure that your secretary is holding that information confidential as well and not just going out and blabbing that. So for those reasons, you get to consider that person to be a confidential position. These are all things we talked about, controlling those lines of communication. Those are the differences between the confidential position and the policymaking position. One of the reasons that we talk about here we'll come back to this, the statute. The reason that the statute exists that says, hey, if you're a new elected official in these certain offices, you get to name your chief deputy and you get to name all those deputies that are allotted in your budget. And the reason for that is that because there's an Indiana statute that basically says those people are that you've appointed those positions are in fact policy-making individuals. I think I've missed a slide there, but we'll go back and find it. Oh, I just flipped right past it there. So one of the reasons is that your deputy and your chief deputy or your deputy 3 or deputy 4 down the line, all of them are engaging in activity on your behalf. And in addition to the statute we read, there's an Indiana statute that says a deputy appointed may perform all of the official duties of the officer who appoints the deputy and is subject to the same regulations and penalties as that officer. Here's what you guys need to know. The officer appointing the deputy is responsible for all of the official acts of that deputy. That is the key that made the legislature come out and say, okay, you guys, you get to name who your chief deputy and your deputies are because we're going to hold you as the appointing officer responsible for the acts of those deputies. So just keep that in mind. That's why certain deputy positions are treated differently than other employee positions. Yes?
Now, I think I've been under the impression as an auditor that I could appoint my chief deputy, but other deputies in the office, we would have to go through the process, the proper process of dismissing them, terminating them. But you're saying they are appointed.
So the statute allows you as the auditor the ability to appoint not only your chief deputy, but all of the deputies that are within your budget. Now, I'm not saying that if you come in and you clean house, you're not going to get sued. You have that statutory authority, though. You have the statutory authority to name not only your chief deputy, but all the deputies that are allotted for in your budget. And that's because when you look at that statute that we just read, it does not distinguish out chief deputies only. You're not responsible only for the acts of your chief deputy. You're responsible for the acts of all the deputies that you appoint. Okay. One of the reasons, move on.
Using that term deputies, in other words, some counties, we as an example, don't use the term for all the positions as other types of deputies. We have a chief deputy, but others have other titles. Are they all deputies?
So in these particular, it's going to depend, and I'm going to tell you this because I don't know exactly what scenario you're talking about, but oftentimes if there's another deputy in the office, they're generally still, from my experience, known as a deputy. What title would you be thinking about?
One title comes to mind, transfer clerk. They transfer property information. It's not titled deputy in the list of positions.
So I'd have to have more specifics on that, but I don't. But the statute is specific, and the statute actually uses the word deputy.
That's why when you said that, I made me think, is there a difference between how they name the
There could be. Now, what I don't know, again, being fact specific, it could be that your county's just not using the word deputy and it's exactly the same thing. Yeah, or it could be that your position itself, based upon your job description, is truly a different position.
And one thing you can't do is name everybody a deputy. That won't work. No, you
We have 10 employees, are we all deputies?
no, you can't do that. But what Libby is trying to explain is there are certain positions that the state statute, if the position falls within the definition of a deputy, it's a free pass to the exception. But you can't expand the statute just by will. They have to fall within that definition.
Right, and again, your job description is going to be relevant to that determination as well. So why is this important? Oh, got another question?
I have a question about, I thought Indiana was like an at-will state. So, I mean, I realize that at-will doesn't necessarily mean you're not going to get unemployment or whatever, but.
So very quickly, the idea of at-will is a topic that comes up a lot, and I hear that all the time. People say Indiana's an at-will state. It is. But what that means is people don't necessarily have a contract and they don't have a right to their job. You can get rid of employees for various reasons, any reason except an illegal reason. So being an employee at will does not mean that you can be terminated based upon your race, your religion, your sexual orientation, politics. All of those are federal rights that apply no matter what. You have the right to free speech even in an employment at will state. You have the right to be employed as a female even if it's an at will state.
So is the burden of proof that you got rid of them on you then to, you didn't violate one of those, like, just because they were, female and you wanted all males or something like that? Or do you have to prove that?
So technically, the burden of proof is going. Technically, the burden of proof is going to be on the plaintiff who's bringing the suit. But this is where it comes back to what I said: is when it comes to me, I'm going to want your documents. And if you say to me, "Hey, it's an at-will state, and I got rid of her for that reason," and she says, "You got rid of me because I was at every rally for your opponent. You got rid of me because I put up 20 signs in my yard supporting your opponent." And you don't have any response as to why you didn't keep that employee. Your only response is it's an at-will state. You've got some liability exposure there. That's one of those you need to have your ducks in a line.
I think that a good rule of thumb is to forget about at-will. And that's because if you think about all the things, the status that are protected, I don't think there's anybody in this room that wouldn't fall into some classification of protection. And so what will happen is if you fire somebody just because you feel like it, you are vulnerable if they are within a protected class, which we almost all are, and they could turn around and say, well, it's because I'm fill in the blank. You know, I don't know how many protected classes there are, but there's so many that we're all in more than one, probably.
So keep in mind that in addition to the things we already talked about, we're kind of limited in the scope of this. Other employment practices that are beyond this are the Americans with Disabilities Act, the Family Medical Leave Act, the Age Discrimination Act. There are so many other, as John said, so many other categories that somebody would fall within. So it's a good rule of thumb to assume that somebody's going to be in one of those categories.
And the second rule of thumb is even if, well, we're all in a protected class, it doesn't mean you can't fire somebody for cause, but you have to have a cause that is not related to one of those protected classes, and in this particular case, political. And you have to have some reason why it's reasonable to expect the person to perform the way they didn't. And have documentation to prove that that was the case. That's really where you need to be.
Does this deputy issue apply to the assessor's office as well?
The assessor does have a separate statute that allows for a chief deputy. There are additional, that statute's longer than the general one that I just read off.
So, documentation is obviously an important
So it's fact specific, but generally they don't get a clean slate just because there's a new elected official. So let's say that every 4 years somebody new comes in, that person who's been written up, 5 times a year for absence issues or for tardiness or for failure to do work, they don't get all those wiped clean just because you've taken over. But keep in mind that you need to still have a legitimate basis for your decision. Don't think that just because they've been written up before and this is somebody who was a political opponent's best friend and you want them out of office, that you can rely upon that documentation, because they're going to come in and say that's pretext.
One of the things new managers have to be real careful of too is you have the lousy employee, you take office, keep in mind that the lousy employee still has a job, which means, at the time they didn't get fired by your predecessor, which may well mean that the employment file, even though they're lousy, doesn't reflect that. As a matter of fact, one of the major foibles of management is you have reviews and you only talk about the good stuff, or you only write down the good stuff, and maybe you have a few bad things, or maybe you don't want to bring up unpleasant things. And so you have a lousy employee, but the employment record looks good. And it's not your record, but you better go look at it, because if it says they're clean, even if they're not, it's going to be a problem for you.
Another question?
You talked about the definition of the deputy, is that written in Indiana code? Is that, you're talking about you have those, here's the job description to the definition of the deputy?
I do not believe there's a statutory definition of that. Yeah.
Is that just like precedence maybe in a case?
There are cases that interpret that.
Okay, and then my next question is, we've talked a lot about if the employee is friends with your opponent or whatever. What if the employee, what is the opponent?
Same thing applies.
Even if it's taking one of the parties, during a primary, she's both Republicans, the employee is the opponent.
Same thing applies. They cannot be terminated based upon their political affiliation. All right, so why are we talking about this? We want you to know all of these ideas of who you can get rid of and who you can't and what the rules are, because if you get it wrong, and even if you don't get it wrong oftentimes, a lawsuit can be filed, and lawsuits are costly. They take up a lot of your time. You end up spending a lot of your first year talking to people like me and giving me your documentation and answering questions, and you get distracted from the whole reason that you took office and all those goals that you had. It gets very difficult to implement those when you're spending your time trying to defend why you got rid of certain employees. It can absolutely cripple the agenda that you had when you took office. And as far as the actual cost goes, some people say to me, who's really going to sue over this? I mean, I fired Sally, and she turned around and she got a job at the bank, and she's making more money at the bank than she was making when she worked for me. Like, why would she sue over this? She still has a right to sue over that. And you may be absolutely right. She may be making more money. Her benefits may be different. She may come in and claim some sort of monetary loss somewhere. She may have gone a couple of weeks without pay. Her lost wages may be minimal. But lawyers take these cases because they're entitled to attorney's fees. And if you violated someone's First Amendment right, they get to make a claim, and Sally then doesn't have to turn around and pay that lawyer on an hourly basis, and she doesn't get a bill to try to pursue it. And if the lawyer thinks that this is a clear-cut case, then he's gonna gladly take it and start tracking his hours, and he's gonna submit a bill to the court at the end, because as the prevailing party, he can get his fees paid. So even if you're looking at it saying this is a low-risk issue, she's not gonna be out any money, she's already got a job, do not think that that protects you from being sued. Yes. There are some. So yes, Indiana in general, it's a 2-year statute of limitations for the state law claims. What we're talking about, a lot of these are federal claims. 2 years would apply again for your First Amendment claim. EEOC claims, so anything that's going to fall into some of those categories. We talked about the protected categories of disability, age, gender, religious affiliation. Those are a 300-day time period when they have to file a charge with the EEOC. The EEOC can take months or they can take years. And during that time period, there is no statute of limitations that runs. So kind of keep that in mind. Just because you clear that 2-year window with somebody on a disability claim doesn't necessarily mean they couldn't bring suit.
We had a question at the booth, and one of the questions was, I take office, and I'm gonna try to get along with my chief deputy. Is there if I don't terminate them right away, is there 30, 60, 90 days? How long will I get in trouble, I guess, if I don't terminate them right away? Is there a statute of limitations on when's a good time to terminate somebody and say, political affiliation, I was gonna give them a go, but they just didn't fall in the line?
So there is no statute of limitations on that. This again comes back to documenting, though. I would be very careful if you're going to keep someone on, basically saying, that this is my person, I'm going to work with them. Let them know what their expectations are. Document whether or not they meet those expectations, and then if at the end of whatever period of time you've set to see if they can meet those expectations, if they haven't met those expectations, you make a decision based upon performance and reasonable expectations. Yes.
Let's say you go in and you restructure your office, and to save money, you lower all the employees' salaries. Just saying. Could they come back at you for that?
So.
Take away their salary that they're making and the bills that they're trying to pay with the salary they're making? Can they come back and get you for that?
You're going to want to look at your salary ordinance and be very careful on some of those things. Question over here.
My question is, what is the difference between hired and appointed? And I ask this because I went ahead and already took the step after recommendation I sat down with our county attorney, our county auditor, and I have already terminated my first deputy. In the letter of termination that the attorney helped me write, I had made the point that you were terminated from your appointed position as the first deputy to the clerk, yada yada, on the dates and times. Her response to me 2 days later was, I was not appointed, I was hired. So can you tell me what the difference is between appointed and hired in a first deputy role for a clerk?
Sure. So in that context, her response is accurate. She is hired, and she is hired for the position of first deputy. The easiest example to show this in is in law enforcement. You have somebody who served as a captain or a sergeant, and when the sheriff's elected, they take that person who's already employed within that office, and they appoint them to be the chief deputy. So that person wasn't hired for that position. The person was already an employee. Same thing goes, let's say that you have your deputy number 4 or your payroll deputy, and you decide that you're going to make that person your chief deputy. They've already been hired to work in your office. They've been appointed to that position. Okay.
What if you have someone that was a part-time employee with the outgoing administration, and in the interim, they're put over to full-time? They're now full-time where they were part-time prior to the election.
Okay, are you talking about like a lame duck sort of appointment?
Full-time, part-time status to now full-time status.
Okay. So generally, when you take office, what's happened previously, you're inheriting a full-time employee, and the rules are the same. They get the same rights for full-time versus part-time. We had one more hand over here.
So when you talk about looking at the salary ordinance and you're looking to restructure salaries, what do you mean about that? So I guess my question is, if you are, there's no job descriptions, let's say you write job descriptions, and then want to make salaries uniform to give everyone job salaries based on their job duties. So some of the salaries change, some people's go up, some people's go down. Is that something, if it's based on job duties, not a specific person at all, but just the requirements of the position?
Okay, I'm going to try to not get into the weeds on this because budgeting is definitely not my area. But I can tell you that you're going to want to look at your salary ordinance. There are generally lines that say this amount is to be paid for this position, this amount is to be paid for this position. And so that's going to be significant when you go to turn in your payroll. they have to be paid out of those line items. And that's why I say you want to look specifically at that. Don't assume that you've got a budget of X number of dollars and you can divvy that up however you want. Yes.
So let's reverse it. Let's say that you have heard your staff is going to leave, and you go to HR, and you ask HR if they've had anyone put in maybe for a resignation or retirement. Are they, by law, obligated to tell you that, or, I mean, you know, if we reverse it, do they have to tell us if we're losing any staff?
They do not. There's no law that requires them to give you that notice. Your handbook may have policies that apply to that. It may say that you get a payout of, you know, PTO time that you haven't taken, sick days. You may be entitled to certain things if you give certain notice. That's a policy. That's not Indiana law. All right. So the one last thing we want to leave you with on all of this is exactly what we started with. If you're not sure if you can get rid of an employee, if you're not sure if they're a policy-making position, if you're not sure if they're a confidential position, if you're not sure if you can change somebody's salary, if you can change their job description, if you're not sure if they're appointed or hired, if you're not sure if they're a chief deputy or a deputy or some other employee, talk to your HR director and talk to an attorney beforehand, because this is not clear-cut. The purpose of today is to give you these ideas. You need to be able to issue spot. You need to be able to know what you can come in. You can't just get rid of people, but there are certain things that apply, and you need to be looking for those.
So if you're getting the idea that this is a really complex set of decisions and full of traps for the unwary, you're right. Is part of the AIC Bliss McKnight program, any of the counties that are involved, if your county is involved, there's a website that has things like model employment, employee manuals, guidance on a lot of the decisions that you've talked about, and different articles that can help you figure your way through this morass, because it is complicated, but with guidance, now that hopefully that you're sensitized to the need to do all of this, you'll be able to figure out the right way and stay out of trouble. Thank you.